Welcome to the Supreme Court of the United Kingdom, where we are resuming the hearing of the appeal in the case of SESC and others, and the Secretary of State for Work and Pensions, an appeal concerned with Social Security law and whether a particular provision is compatible with rights guaranteed by the European Convention on Human Rights. We're hearing submissions at the moment on behalf of the appellant from Mr. Richard Drabble, Queen's Counsel, and I'll invite Mr. Drabble now to resume his submissions.
Yes. Well, can I first of all say something about timing? There's been some discussions between the respondent and myself about how to deal with the timetable. And if the court is happy, our preferred position will be only to sit until 4 today. That is, not to accept the court's invitation to sit beyond that, on the basis that it's already been quite a long day, even if we haven't been talking all that much. But secondly, to accept the court's invitation to sit at 10 o'clock tomorrow morning, if that will be acceptable. Yes. I suspect that if we do that, the rest of the timetable will play out fairly naturally, and we will be on course. Yes. Probably with a sitting until 4:30 on tomorrow, but we may not need that. We'll see where we get to.
Thank you very much. That'll be fine.
So, well, Lord Milady, I before the short adjournment, I had been isolating 6 characteristics of the position as it can be developed from both the statutory material and the policy material. Now, we do say that in those circumstances, Article 8 is directly engaged, and there is no need, therefore, we say, to look at the various sensitivities which can be acute involved in this case through the prism of Article 14. This is a case in which the measures potentially evince a lack of respect by the state for the family life of both the mother and the children, which requires justification under 8.2 if it is to be justified at all.
Yes. Can I just ask, Mr. Drabble, have you finished your presentation on the facts?
I've finished what I intend to do on the facts so far. Yes. Well, the answer is yes. If there are issues that the court wishes me to go further into, then of course I'll do that. Well,
I wonder if there's just one matter I might raise with you.
Yes.
You've taken us to the impact assessment that was done by the government.
Yes.
Ultimately, of course, the provisions that we're concerned with were enacted by Parliament.
Indeed, they were.
And Parliament will have received a great deal of other material, including, I think, material submitted by the Child Policy Action Group, concerned specifically with the impact of the what were then provisions in a bill on the children who would be affected by it.
Yes, that is correct, and your lordship will obviously have seen the witness statement of Alison Garnham, which is in part 2 of the appendix.
Yep.
Plainly, as a description of the impact of the measures, I rely on that. There is going to be an issue when we come to consideration of best interests and Article 3 as to how one approaches in a compatibility case, which obviously this is, deliberations in Parliament. And I will have certain submissions to make about the relationship between parliamentary proceedings and Lord Nichols', the passage from of course, with which your lordship is more than familiar, in Upson and First County.
Yes.
But
yes, thank you.
I of course fully accept both the representations were made to Parliament about the potential impact of the measures. The description of the measures I positively rely on as showing what is involved and as being correct. And secondly, I say when it comes down to the detail of Article 3, that the simple fact that representations are made about where the best interests of children might or might not lie, does not discharge the duty placed on the UK, probably the correct characterisation of what we're dealing with, to treat the best interests of the affected children as a primary consideration. That best interest issue is it's a major issue in the case, which I shall be coming to. If that's acceptable. So going back, before we get to that part of it, which I'm going to deal with that after I've outlined our position on discrimination against children as a class, and again, after we've outlined our position on discrimination against families or households with 3 or more children. There's an issue about status in there, which I need to say something shortly about. But our first port of call is that Article 8 itself is directly engaged by this restructuring of the benefit system. And it is, my use of the word restructuring is deliberate. What is happening here is the creation of a particular structure of the benefit system, which creates the problems for the individuals affecting profoundly their personal life, with which this case is concerned. It's that aspect of the analysis which distinguishes this situation from the paradigm position, in which I completely accept that both the domestic and Strasbourg case law says the state is to the effect that the state is under no obligation to provide a benefit at all, and therefore failure to do so does not breach Article 8. That line of authority I accept, which is how to apply the principal case law in the particular circumstances of this case. And we're not aware of there being any parallel situations being considered either by Strasbourg or domestically. If the court will turn up our printed case, EF 94, court will see there's a heading halfway down the page, Articles 8 and 12 engaged and breached, issue A of the Statement of Facts and Issues. Paragraph 27 says what I've just said, essentially, novel intrusion by the welfare state upon intimate choices of low-income families, which is incompatible with Articles 8 and 12. And then 2 submissions are made about the reasoning of the Court of Appeal in paragraphs 23 to 24 of the judgment, which I'll go to in a moment, and in paragraph 35 of the judgment. So if the Lordships will, and the lady will go to EF 208, page 208 of the electronic file. Paragraphs 23 and 24 are on that page. And Lord Justice Leggett says, in these proceedings, the claimants have asserted that the measure had a further aim of influencing behaviour by creating an incentive for people on benefits to have smaller families. And then it refers to me highlighting statements which I highlighted to your Lordships and the lady, encouraging parents to reflect carefully on their readiness to support an additional child could have a positive effect on overall family stability. In practice, people may respond to the incentives this policy provides and may have fewer children. Judge, as Mr. Justice Ouseley, found that it was clearly anticipated that an effect of the measure might be that some people would decide not to have a child when they might otherwise have done so, but he rejected the contention that discouraging larger families could properly be described as an aim of the legislation. Judge also found there is, at least so far, no evidence from which it can be inferred the legislative change is having an effect on decisions made about family size. And then I have seen no basis for challenging these findings. In particular, there's no reason to attribute to government, or to Parliament, any aims in introducing the 2-child limit other than those which were expressed repeatedly stated during the process. The aims of the measures do not include any goal of reducing a size of family. Now, as we say, Your Lordships, and we're going to go back to the printed case, it's not part of our case, not a necessary part of our case, to label the intended and known effect of the measures, which would be an influence on the profound relationships within the family in all the senses that we have described in our printed case, as an aim, as a measure. All that's necessary for our case on the direct engagement of Article 8 is that it was a known and intended effect. The measure depends for its efficacy and acceptability in anybody's eyes on the proposition that the practical consequences could be dealt with by either abstaining from sexual relations, using contraception, or contemplating abortion, or whatever. Those are known and intended consequences of the policy. Now, that is an effect which is outside the run of cases which the Court of Appeal dealt with as the classic cases on direct engagement of Article 8 in terms of income provision, which the Court has dealt with at, in the run of paragraphs that leads up, I think, to paragraph 30. At EF 210. So Your Lordship and my Lady will see the passage starts at 29 on the foot of page 209. The root difficulty facing the claimant's case is that the Convention is not aimed at securing social and economic rights. Rights reflected in the Convention are predominantly civil and political in nature, and then there's an explanation of why that is. And then in paragraph 30, Lord Justice Leggett goes on to say that the case law has identified the essential object of Article 8 as being to protect the individual against arbitrary interference from the state. The Court has not interpreted Article 8 in wholly negative terms and has indicated there may be positive obligations inherent in the respect for family, private or family life. See, for example, Marx. But then summarising the main thrust of this line of case law, which I accept, Article 8 has never been held to impose an obligation on the state to have in place any positive programme of financial support for private or family life. Then there's a reference to Petrovich and a reference to domestic cases to provide to the same effect. Now, we do say that if that it's possible to discern, and the Court should discern in the present circumstances, an intended impact on family and private life, which is outside the run of the case law which deals with the absence of a positive obligation on the state to provide financial support. The last sentence of paragraph 30 of Lord Justice Leggett, Article 8 has never been held to impose an obligation on the state to have in place any positive programme of financial support for private or family life. But something else is happening here. That's the crucial thing. What is happening here is that the state is introducing a structure of welfare benefits which is intended to have the effect of making individuals think about their sexual life and and whether or not to continue a pregnancy and so on. All those matters are necessarily in play. That is not covered, we say, by any of the classic cases. So if, for example, one goes to Bota, which the Court of Appeal deals with, at the foot of page EF 211, and comes to the conclusion that it doesn't help me. But can we just have a look at what Bota does or decide or does contemplate? Your Lordships will pick up, or will pick up EF 1450, Authorities Bundle 1. Some members of the court were very familiar with Bota, and I can just remind the court that the actual circumstances were a disabled man who wished to go to the seaside and access disabled facilities with enabling access to the beach and sea, complained that the bathing establishments were not equipped with disabled facilities enabling access in breach of the Italian legislation. And he said Italy was in breach of a positive obligation under Article 8 by not enforcing those obligations on private individuals. And the court, that allegation of breach of a positive duty failed. The subject matter of the dispute was summarised in paragraph 27, page EF 1464. The court can see paragraph 27, the first part of paragraph 27, before Article 8 itself is set out, describes the lack of access. And then the crucial assertion is that's underneath the indent, underneath the text of Article 8. He asserted that he was unable to enjoy a normal social life, which would enable him to participate in the life of the community and to exercise essential rights, such as his non-pecuniary personal rights, not because of interference by the state, but on account of its failure to discharge its positive obligations to adopt measures and to monitor compliance with domestic provisions relating to private beaches. And then if the court will go on to paragraphs 32 and 33, paragraph 33 states, in the present incident case, the applicant complained in substance not of action, but of a lack of action by the state. While the essential object of Article 8 is to protect the individual against arbitrary interference by public authorities, it does not merely compel the state to abstain from such interference. In addition to this negative undertaking, there may be positive obligations inherent in effective respect for private or family life. These obligations may involve the adoption of measures designed to secure respect for private life, even in the sphere of the relations of individuals between themselves. However, the concept of respect is not precisely defined. In order to determine whether such obligations exist, regard must be had to the fair balance that has to be struck between the general interests and the interests of the individual, while the state has in any event a margin of appreciation. And then crucially, the court has held that an obligation of this type The court has held that the state has obligations of this type where it has found a direct and immediate link between the measures sought by the applicant and the latter's private and or family life, with reference to area and so on. Now, two matters arise from that. First of all, was the observation in the middle of paragraph 33 that the concept of respect is not precisely defined. It's obviously correct, but it is the starting place. The issue in this case is whether the structure of child tax credit and universal credit, which creates what we described as the cliff edge in the printed state, does demonstrate a lack of respect for family or private life. And doesn't get to that simply by demonstrating an absence of support, financial support, that I accept. Do you get that by creating a structure of benefits which depends for its efficacy upon judgments about whether or not it's appropriate to have children, whether or not it's appropriate to abstain from sexual intercourse, whether or not it's appropriate to have abortions, and matters all of that sort, family involved, intimately involved in private and family life. So that's the first point. And the second point is paragraph 34. Court has held that a state has obligations of this type, where it's found a direct and immediate link between the measures sought by the applicant and the latter's private and or family life. Well, we do submit that this particular structure of welfare benefits does create a direct and immediate link between the measures sought by the applicant, namely a structure, the measure sought by the applicant on this argument will be a structure of benefits which did not entail the cliff edge of a sudden lack of provision once the number of children exceeded 2, with all the consequences that has for private and family life. You can achieve financial objectives in all sorts of other ways by assessing the amount of income that is necessary, or for a graded reduction in scale of resources. If the structure you actually choose is a complete cessation of a benefit once you have more than 2 children, then the structure, when there is a direct and immediate link between the measures sought and the measure we would seek, would be a different measure that did not create the cliff edge. It's the essential submission in this part of the case. And so Bota clearly doesn't get me home at all. None of these cases are dealing with the issue that we have to grapple with here. But equally, we are far removed from the paradigm case of a complaint about lack of resources being provided by a family constituting direct interference with private or family life contrary to Article 8. We get the same point if we go, well, first of all, if we go via Petrovich, but only to make the negative point. Petrovich court will find at EF 4098. Just tab 9. Oh, sorry, you don't need that. It's my authorities bundle 9 at tab 93. Petrovich was the case, as the court will know, about a paternity allowance. And as Lord Justice Leggett comments in his judgment, there wasn't on the facts of that case any direct engagement of Article 8 at all. It emerges clearly from page 4100, EF 4100, sorry, EF 4110. My fault. And the paragraph that's quoted by Lord Justice Leggett is paragraph 26. In this connection, the court, like the Commission, considers that the refusal to grant Mr. Petrovich a family leave allowance cannot amount to a failure to respect family life, since Article 8 does not impose any positive obligation on states to provide the financial assistance in question. And then paragraph 27 lays the foundation for ambit. Obviously, we rely on paragraph 27 when we come to further bits of the analysis, for saying that the scheme of reform of child tax credit and universal credit is within the ambit of Article 8. Tacit paragraph is paragraph 28. The court has said on many occasions that Article 14 comes into play whenever the subject matter of the disadvantage constitutes one of the modalities of the exercise of the right guaranteed, or the measures complained of are linked to the exercise of the right guaranteed. By granting parental leave allowance, the states are able to demonstrate their respect for private life, for family life, within the meaning of Article 8. And therefore, Article 14 is applicable. Petrovich is just an example of the relationship between the concept of ambit and the classic line of authority, no direct engagement of Article 8 by the absence of financial support. But if we go on to the final case that I'm going to go to on this aspect of the case, it's a case of marks. The court will find at EF 3775 is in fact Authorities Bundle 8, tab 86. It starts at EF 3775. And the complaint is summarised in the head note, once again is removed from the facts of the present case. The first 2 or 3 lines of the head note, and they will want to identify the complaint. The applicants, Paula Marks and their infant daughter, Alexandra, complained that certain aspects of the illegitimacy laws in Belgium, including the requirement that maternal affiliation could only be established by a formal act of recognition, infringed Article 8. That's the sort of nature of the subject matter. The key passage, which Lord Justice Leggett no doubt had in mind, is at EF 3786. And if we pick it up, paragraph 31 towards the foot of the page, first question for decision is whether the natural tie between Paula and Alexandra Marks gave rise to a family life protected by Article 8. And then there's an identification of what's involved. By guaranteeing the right to respect for family life, Article 8 presupposes the existence of a family. The court concurs entirely with the Commission's established case law on a crucial point, namely that Article 8 makes no distinction between the legitimate and illegitimate family, and explains why that is. And then, importantly for these submissions, goes on to explain what's involved in the concept of respect for family life. But picking it up again, a third of the way down the page, 3787 on, it remains to be ascertained what the respect for this family life required of the legislature, Belgian legislature, in respect in each of the areas covered by the application. By proclaiming in paragraph 1 the right to respect for family life, Article 8 signifies first that the state cannot interfere with the exercise of the right otherwise than in accordance with the strict conditions set out in paragraph 2. As the court stated in the Belgian linguistic case, the object of the article is essentially that of protecting the individual against arbitrary interference by the public authorities. Nevertheless, it does not merely compel the state to abstain from such interference. In addition to this primarily negative undertaking, there may be positive obligations inherent in an effective respect for family life. This means, amongst other things, that when the state determines in its domestic legal system the regime applicable to certain family ties, such as those between an unmarried mother and her child, it must act in a manner calculated to allow those concerned to lead a normal family life, as envisaged by Article 8, respect for life, family life, implies in particular, in the court's view, the existence in domestic law of legal safeguards that render possible, as from the moment of birth, the child's integration in its family. In this connection, the state has a choice of various means, but a law that fails to respect this requirement violates paragraph 1 of Article 8 without there being any call to examine it under paragraph 2. So we say that the critical issue in this part of the case is how to fit the restructuring of a benefits framework into the sort of conception that case Marx has, about legal safeguards that render possible, as from the moment of birth, the child's integration in its family. Now, it is no obligation to provide state benefits at all, but a structure of benefits that creates the cliff edge we've tried hard to describe in the case is incompatible, we say, with the state's obligation to consider and facilitate the child's integration in its family. It simply creates a particular and acute problems for family life just because of the structure of the benefit reforms. So we completely accept that you do not get from either Marx or Boter an answer to this case. But similarly, in my submission, one does get a framework for taking into account very particular features of this regime. And for those reasons, we do submit that Article 8 is directly engaged without the need to look at the issues through the prism of Article 8 read together with Article 14. Now, I think we say in the case many of the sensitivities that emerge in an Article 14 analysis the particular impact on women, the impact on religious beliefs about sexual behaviour, and so on, all sound in an Article 14 justification case. We say there is no legal policy reason why they shouldn't also sound as part of an analysis as to why something different is happening here from the traditional analysis of there being no positive obligation on the state to provide welfare benefits, which is I repeatedly say we accept. And for all those reasons, we say Article 8 is directly engaged, and that the judge Justice Leggett was wrong to hold to the contrary. These are my submissions. I think Lord Stevens has a question. Lord Stevens, I think you're muted.
No, you're definitely muted.
Still muted. Wish I could do this too. Well, I never mind.
Lord Stevens, you're going to have to wait until our engineer has worked out how to solve your problem. I'm told that we need to adjourn in order to get this problem sorted out. So we will adjourn the hearing, and our engineer will get in touch with Lord Stevens and sort out what the problem is. We've been more than usually troubled by technical problems today, but I think we're now ready to resume the hearing. I think Lord Stevens had a question to put to Mr. Drabble, Queen's Counsel.
Yes. Sorry, Mr. Drabble. I was wondering whether your submission in relation to Article 8 was both from the perspective of the parent and also from the perspective of the child, or the children involved. As far as the parents are concerned, I have some difficulty about the concept that this isn't normal life. That is, that lots of parents have to make these intimate decisions. I can accept provisionally that these provisions do have an impact on the intimate relationships of the parents. But that is something that all parents struggle with and is a part of normal life. I also have a difficulty with it always coming back to benefits. The solution to the problem is the payment of benefits. So those are the two problems I have in relation to the parents. But I was interested more in your concept about the children and that they are unable to integrate in family life if in fact they are deprived of the wherewithal, the financial wherewithal. So I was just wondering whether or not the two arguments, the arguments in relation to the parents can really stand scrutiny, but I was more interested perhaps in the argument in relation to children.
I think I certainly rely on the arguments in relation to children. We do say, well, I mean, the next section of my submission is to deal with our case that there is discrimination against children as a class in this group, and failure to respect the individual children involved. So I certainly do say there's an adverse impact on the family and private life of the children, which is beyond their control, which there's no need to analyse through the prism of Article 14, which is the next section of my case. It's simply a concomitant of this structure of benefit. That also leads on to my answer to your Lordship's question about the position of parents. One of the things I've tried to do in our printed case is to resist, I hope it doesn't sound too pejorative, but a salami slicing process to the problem. You look at Article, I mean, there's a great temptation that you analyse it on the basis, well, Article 8's not engaged directly, because here is a line of authority, which includes Petrovich, for example, the classic dicta. So you put Article 8 to one side, then you look at Article 14 in relation to the children, and the position of the parents are not in play in that analysis. And then you look at the position of women, and you're not looking at the position of children. My fundamental submission is that you only get hold of the full force of what is happening with the two-child rule if you look at the overall picture, and that if you're looking at it as a matter of legal policy, what factors should be in play, then all the factors that are sensitive, like the relationship between the parents, like the impact on the children's ability to integrate, and so on, they're all in play, and they ought all to be brought into play rather than looking at it in a set of isolated boxes. And you've got to do that. But it's very important, we submit, to resist too great a compartmentalisation. I was probably going beyond answering your Lordship's question, for which I apologise. But I certainly do say that there's an impact on the development of the children if you apply the dicta that we've just been looking at in Marx. Doesn't matter. If you apply the dicta we've just been looking at in Marx, this benefit system does create a framework within which the private lives of the children, as well as of the parents, are to be developed.
Can I just ask you, Mr. Drabble, to clarify this? One can readily see on the facts of Marx that the refusal to recognise in law relationships between a child and members of what de facto were its family would obviously affect its ability to integrate into the life of that family. But why do you say the same about a limitation on an element of a social security benefit that a family or child's parent or other responsible adult receives?
I don't say exactly the same, because I don't say that, well, I don't say it is the same, because Marx is, I quite agree.
Yeah, it's an obvious case.
It's the significance is in its relationship with the concept of positive obligations. You have, just while I'm talking, I'm just trying to find the passage that we were looking at. Your Lordship says it's an obvious case, but the stepping stones in Marx are stepping stones on the way to an analysis which is dealing with the formal requirements necessary in the Belgian system for recognising the relationship between the mother and the daughter. It's EF 3787. I'm not finding it clumsily.
Yeah.
So I don't say what your Lordship is putting to me is my reference to, as envisaged by Article 8, respect for family life implies in particular the existence in domestic law of legal safeguards. But the court is seeing that as a positive obligation to have in place the requisite legal machinery for bringing about a full private life. I'm paraphrasing badly, but that's essentially what I think the court is saying.
Yeah.
We don't have that here. I completely accept it's not on all fours. What we do have here is a situation where the state could deal with the possibility that too much benefit was being paid for families with 2 or more children. For example, you could have an analysis that just says adding up all the different components of individual children overcompensates, if that's the right word, in a benefit framework, because the cumulative effect is too large. State here hasn't done that at all. It hasn't gone through any analysis that says you're getting too much money because the cumulative nature is too big. We are just putting down a shutter at 2 children. Now, that is the state positively arranging its benefit framework in a way which creates all the effects we've tried to deal with in the printed case. Now, if you want to analyse it in terms of positive obligations, we say that the state has a positive obligation not to create a benefit structure which has that distorting effect.
So there's an obligation under Article 8 for benefits to carry on increasing whether a successive child, however large the family may be.
No.
That's an obligation imposed by Article 8.
A positive obligation not to have an arbitrary, sharp cutoff with all the consequences. That's what we've tried hard to say in the case. The vice here is not a reduction in the payment of benefits. The vice is the particular structure which, in straightforward Article 8 terms, ignoring Article 14 for a moment, and the need to get into analysis which engages status and so on. Straightforward Article 8 terms, you have a cliff edge in which people engaged in a perfectly ordinary private and family life will find themselves faced with choices with dramatic financial consequences which they cannot control. Now, that's a product different from the simple quantification of state benefit. It's an impact different from the simple quantification of state benefit. And that's my case. I can't put it better than that. I'm not going to apologise for it. That is my case. But it's not a simple case of not paying progressively more money. It's not even a simple case of reducing money.
They do, in fact, pay progressively more money. It's just not as much as you assert is necessary. Your clients actually received more money once they had additional children because they got child benefit.
Yeah, well, they receive more money, but not for the subsistence income. Right?
Yeah.
Subsistence. They receive more child benefit, certainly. I mean, I can't avoid the fact and don't avoid the fact to some extent. That's a question of fact and degree, isn't it? I mean, this is a very, very sharp measure, which depends for its efficacy upon the view that people will think about whether or not to have more children, and imposes a very sharp cliff edge. And that structure is not the same as the debate about whether or not to have child tax credit at all, or the quantum of child credit. It's a particular provision.
Lord Sales has a question.
Yes, Mr. Abbott, it was really pursuing, I think, the same line of thought. Yeah. I'm having some difficulty with the idea that even looking at it from the point of view of integration of the child, one's within Article 8 and steps outside the Petrovich line of authority, because isn't the basic problem of family resources being stretched thinner and thinner the more children a family has, inherent in lower income working families and the choices that they have to make and the position their children will find themselves in, even though they're above the thresholds at which benefits would be payable? So in the end, doesn't it resolve down to an argument that the state has to pay benefits to ensure children's resources or resources available for children are maintained at a particular level? And why should that be restrained to the case of families that are on benefits as opposed to families not on benefits?
Well, I don't accept it reduced down to that. So you take, we have a piece of benefit reform, namely the Act which contains sections 13 and 14. It takes place in a given legal system. It doesn't take place in a vacuum. It takes place in a given legal system. You look at what the desired consequence of the change are, and you ask yourself whether or not that is an effect on the individuals concerned, which requires the state to justify by reference to Article 8.2. It's not a prohibition. You have to show that the imposition of this effect is something which is justified under 8.2 on this analysis.
Yes, thank you.
And the key thought, in answer to your Lordship's question, is it's not abstract. It is this legal system, this system of benefits, and these effects on the children and parents concerned in the real world. Now, those are my submissions on the Article 8. We then move on to the next step in the argument, which is to leave aside the direct engagement of Article 8 and to proceed to an argument that the two-child rule directly discriminates discriminates against children as a class, for comparison being adults generally. And your Lordship, my lady, will look at EF 98 and 99. We'll see, will be, I hope, in the part of our printed case which deals with this. We set out in paragraph 42 core submission that reforming the social security system in a way which removes subsistence benefits for some children and does not alter subsistence benefits for adults constitutes discrimination against children on the ground that being a child is a relevant status for Article 14 purposes. However, the Court of Appeal rejected that argument for the reasons set out at paragraph 81. And Your Lordship's going to be quoted from paragraph 81. The key thought in Lord Justice Leggett's judgment was the two-child limit on child tax credit does not disadvantage children in comparison with adults, since child tax credit is a benefit that is payable solely in respect of children. There is no equivalent welfare benefit payable in respect of adults. Now, we say that's wrong, and the reason why that's wrong depends upon an analysis, a correct identification of the benefit system that's in play. We've tried to describe it as paragraphs 41 to 47 of the printed case. In particular, it's 45 to 47, page 99, EF 99. And we say in 45 there are equivalents to child tax credit for adults, mainly income and support, job seekers allowance, employment and support allowance, working tax credit and pension credit. They are equivalent in that they are part of the UK system of means-tested cash benefits supporting people who have no other income, which attach to adults. And 46 is about the basic structure. Child tax credit and the adult benefits all contain a basic per capita personal allowance, which may be topped up with premiums largely related to disability. They're all benefits which guarantee a minimum subsistence income and which are progressively withdrawn at higher levels of income. As stated in the essay, in paragraph 3 of the SFI, they form a single subsistence benefit system. And we say in 47, the first detailed reference we've had to the universal credit parallel to CTC, but it is important. The comparability of subsistence benefits intended for adults and children is even clearer under the new system. UC includes an amount in respect of children's needs, the child element playing the same role as CTC, and an amount in respect of adults' needs, the standard allowance, and it is a single household benefit. Note also for much of the history of the United Kingdom's social security system, the introduction of tax credit, amounts for children were payable as part of household benefits, such as supplementary benefit and income support. Now, Humphreys, the judgment of Lady Justice Hale in particular, Humphreys, is what puts some flesh on the bones of this contention, that the amount payable for children and the child tax credit or under UC, universal credit, is exactly equivalent to the components of universal credit. For example, take a simple example, which provides a subsistence income for adults, but one is affected and the other isn't.
Mr. Drabble, but why is it that you're focusing solely on the individual element of child tax credit? Child tax credit isn't paid at all to adults unless they are responsible for children. So the way you put it, it's not as if there's a family element, as it were, or whatever it's called, which is for the adults, and the individual element is for the children. The entire benefit must be for families, if you like, with children.
Yeah.
But I'm not sure if I just don't know. Is universal credit the same? Because you say that does include an amount in respect of children's needs, and something called the standard allowance, which is in respect of adults' needs. Is there any difference between the two benefits?
No. What your lordship is doing is with respect, I would say, making the mistake that Lord Justice Leggett has made, that is looking at child tax credit in isolation, saying child tax credit is not concerned with adults, therefore there's no analogy to be drawn with the position of adults and no potential for discrimination between adults and children. The true position in my submission is this. If you look at the position before universal credit, so that's rolling over on a postcode basis, as the court probably knows rather slowly. The true position before universal credit is that if you were, say, unemployed, the adult subsistence needs will be dealt with by a legacy benefit, as the jargon in the trade goes, the most obvious one being job seekers allowance.
Yeah.
And so that deals with the subsistence elements of the pre-universal credit position, the legacy position. The children's position is dealt with, your Lordship entirely correctly puts to me, by CTC. The impact of these reforms is concentrated solely on the element that deals with children. It deals with and leaves untouched the part of the legacy system that deals with adults. And when we get to universal credit, there's a single benefit which plays the role both of the legacy benefits, the old role, now overtaken role of the legacy benefits. So JSA on this scenario is irrelevant, ceases to exist for any family under the new regime. But instead of which, the standard allowance, if your Lordship, lady, just look at paragraph 47, the standard allowance in universal credit was taken over from JSA. So instead of JSA, the adult gets the standard allowance. And instead of child tax credit, the adult gets for the child element. Now, what the Court of Appeal did to meet this argument, to meet the argument there was discrimination against children, is to say, well, child tax credit is a benefit that's payable solely in respect of children. Well, at one level, that's completely true. But if you're trying to describe the benefit system in a holistic way, it will be a nonsense to describe the benefit that is responsible for dealing with families as confined to CTC. It isn't. It includes the legacy benefit, which goes to the parents. So the plea in this part of our case is to characterize the benefit system properly. So in the legacy regime, you look at the legacy benefit plus CTC. In the universal credit, you just need to look at universal credit. Lady Black has her hand up.
Sorry, I was waiting to be unmuted. Would it be fair to describe, is this too simplistic, that all those in the system who are reliant on benefits have attributed to them and for their subsistence, except the children in the household where there are more than two children?
No, that's not too simplistic. That's exactly our case. And I just repeat, that's the case we made to the Court of Appeal. And the case against us was, well, it doesn't get you anywhere because there is no element, because CTC, which is what you're complaining about, is payable only for children. Well, yeah, that's true, but it ignores the fact that there is a subsistence element paid to the adult which is untouched by the reforms. So I think we put it possibly too dramatically, but nonetheless we did it. Paragraph 1 of our printed case, EF 86, describes the reform as possessing the novel feature of requiring the existence of some individuals in a household to be disregarded indefinitely when calculating that household's entitlement to subsistence benefit. Now, I think that's what your ladyship is essentially putting to it. I mean, put in slightly more dramatic language there, but you look at the system, you look in the legacy regime, what adults and children get. They get JS, Job Seekers Allowance, plus CTC. In the universal credit, they get something. Which set of subsistence needs possessed by an individual is not met? And the answer is solely those in respect of third and subsequent children. Everyone else is in the frame, and everyone else puts, as it were, something into the pot of the calculation. We're getting a few metaphors mixed up. But
I thought that the most classic comparison between children and adults was a person who had been a child living in a household who achieves a certain age and is no longer a child and then is entitled to benefits
yes,
without any reduction whatsoever. And he, as an adult, is being treated totally different from the children.
yes. But I would positively refer to that example as an example of the underlying complaint. It's a way of demonstrating that there's a particular group falling out of what should be a coherent benefit system. Who is falling out of the coherent benefit system? That is, the child born after, in a family of the right size, or where there were already two children, born after the 6th of April 2017 until he reaches the age of majority. Then he comes back into the frame. Now, obviously, in many lives, he will have gone in and out of work and in and out of benefit on the way. But I mean, that is the analysis.
I'm afraid I'm not following this at the moment. Why is a person in a household who's an adult and receives benefits as an adult, for example, job seekers allowance if he's unemployed, why is he a comparator with a child in a household where the child tax credit payable to the parent in the household is limited in the way that we've been discussing?
Well, the vice of the problem that we're identifying is on the basis that we're dealing with a situation where both job seekers allowance and CTC providing for subsistence needs. Let's call the subsistence needs of an individual £10, far removed from the actual figures. But you have a situation in which the subsistence needs of the two children born before April 2017 are met, 20 quid in the family in the pocket. Another child is born, no further £10 comes in. When the child gets to the age of majority, then he's back receiving a full adult version of the £10, or being paid in respect of him. I think that doesn't matter who the legal entitlement is with. His subsistence needs, his or her subsistence needs are in play, either if you're in a family of two children, or was born before April 2017, or is adult, but not if you're in the group in the middle. That's the Court of Appeal dealt with that problem by, and I'm getting addicted to salami slicing, I'll have to stop it, but by saying, well, you look at each component of the benefit system separately, and so there is no comparison between CTC and the legacy benefits, because CTC is paid solely for children and JSA is both paid solely for adults. But that is, in a way, a truism. They're both the benefits that are designed to be part of a coherent benefit system, providing for the overall needs of those without other resources, on the example of maximum entitlement.
And the difficulty seems to be that adult security is payable to individuals, whereas the children, the benefits in respect of children seem to be paid on a household or family basis rather than on an individuated basis.
The legal entitlement is certainly with the parents.
Yes.
And I took your lordship to the provisions in the legislation dealing with the issue of identifying the parent who is entitled to the money for the child. And in essence, it's a concept of responsibility. The person who is responsible for the child gets the money.
Yeah.
But behind that is an identification of a cash amount, the subsistence amount, which is paid in the case of adults to the adult, ignoring problems of capacity and so on, essentially paid to the adult. In a pre-reform situation, a cash amount is identified for each child, which can vary according to age and so on. But it is identified for each child and is paid to the person responsible. It's the identification of the cash amount, which is for subsistence, for living needs, don't mean for living needs, which is constant between the two systems. So, as Lady Black puts it, I mean, I'd say the simple, but I mean, the straightforward and correct way of looking at it is that the needs of every individual are taken into account in the system, apart from the needs of children born to families of 3 or more after the start date of the new regime. Everyone else's needs are in play. That is the cornerstone of the argument that the scheme discriminates against children.
Thank you.
And we have said, if we go back to our printed case, just trying to relocate myself. We're back in EF 99. We have cited McLaughlin, paragraph 24, and the plea is for a broad approach, a formalistic approach. The plea is that a formalistic approach to comparability is inappropriate, and cited McLaughlin. And you're probably familiar with the dicta. If you need a reference in the electronic file, it's to EF 1205, we'll actually find the quotation. I don't think it's necessary for me to look it up anymore. But the reason that that's there in the printed case is to meet the perspective that Lord Reid has been putting to me, that there is a difference, a necessary difference, which sounds in the analysis, between the position of children in a household where the benefit is paid to the person responsible for the children, i.e. normally to the household as a whole, and adults who claim it themselves. We say that's looking at the form, not the substance of the benefit system. So that's precisely why 48 and 49 are there. And if possibly helpful at this stage to pick up Humphreys, which the court will find it in electronic file page 1137. So that's A1, notice bundle 1 in my language, EF 1137. Humphreys is about child tax credit. The issue was whether a rule which said that the child tax credit always went to the majority carer. So you have a situation where mum looks after the child for 4 days a week. Mr. Humphreys looked after his children for 3 days a week. The mother gets the whole of the child tax credit. The argument was that that indirectly discriminated against men, because the majority of minority carers were men. The legislation should be held to be discriminatory on that basis. Now, the answer, first of all, if your court was to be found in the overall purpose of child tax credit, which was paid, despite being paid legally to the parent, is paid in respect of the child's needs. And the Lordship and the lady will see that paragraph 25. EF 1147. And this is Baroness Hale recording the revenues case, that I think is a reasonable influence in the judgment as a whole that she accepted as part of the revenues case. The revenues case is also simple. The aim of child tax credit is to provide support for children. The principal policy objective is to target that support so as to reduce child poverty. The benefit attaches to the child rather than to the parent, It's paid to the main carer because the main carer bears more of the everyday expenditure for the child and most of the capital expenditure on things such as clothes, shoes, sporting and leisure equipment, school trips and the like. Splitting the benefit would reduce the amount payable to the main carer, is usually the one less well placed to earn income. The result in neither household being able to afford items such as clothes and shoes. Well, most of that's concerned with the justification for what we called in the litigation the no splitting rule. The key sentiment is the benefit attaches to the child rather than to the parent. Now, that's not legally true. It's the parent who is responsible, even under the CTC regime as we've seen, who is responsible for. The parent is the person responsible for the child who claims the benefit. But the idea is that you're producing a sum of money for the child. Attaches to the child rather than the parent. And if the court goes on then to see Baroness Hale's description of the reasons why this approach is reasonable, you will find it in paragraphs 30 and 31 of the judgment at EF 1149. And she is describing the advantages of the child tax credit system. Introducing it all, as the rule is also linked, at the beginning of paragraph 30, the rule is also linked to the move from tax allowances and social security benefits into a seamless tax credit system. When child addition assistance child benefits were decided on a week-by-week basis, practical though not the conclusion on all of that is the last 4 lines of paragraph 30. The introduction of child tax credit, working tax credit, was a step in that direction. In my view, it was reasonable for the government to take that step and to regard the targeting of child support to one household as integral to it. Also reasonable for the government to regard the way in which the state delivers support for children and indeed for families as a separate question in the way in which children spend their time. The arrangements which separated parents make for their children are infinitely various and varied. So basic thinking is that CTC produces a sum of money which attaches to the child rather than to the parents, despite the legal formality that is paid almost necessity to the majority carer. All of that fits with our analysis of what is happening here. Is discrimination against children, because they are the only ones who fall out of the framework altogether. And we say, going on to our printed case, your Lordships will turn up paragraphs 53 to 55 in our printed case at EF 101 to 102. We say, under the heading Children Now Treated Worse Than Adults, towards the foot of page EF 100, violation of dignity. Basic problem being that if the children concerned are now or in the future part of a large family contingency which they are unlikely to be able to control or even influence, their existence may be ignored for the purposes of calculating subsistence benefit entitlement, and their per capita support will be lower.
Well, it will be lower, Mr. Drabble, won't it, for the particular benefit we're concerned with, which is the individual element of child tax credit, but it won't be ignored for any other purpose.
No, but the adult equivalent on this argument of the individual element of child tax credit is job seekers allowance, because we're dealing with legacy benefits if we're dealing with child tax credit. That's completely unaffected by the reforms.
So the comparison is between children and adults in receipt of
it is
job seekers allowance, is it?
The first answer to that is we caution against a too formal identification of the comparator. But yes, the position is that if you look at the position of children on the one hand compared to the position of adults on the other hand, if they are in need of a subsistence benefit, by which I mean a benefit providing for all the things referred to by Baroness Hale in the passage from Humphreys we've just been looking at, the adult gets the money to pay for that sort of thing, and the child doesn't get the money to pay for that sort of thing. I mean, it is actually as simple as that. And the fact that they also receive other benefits doesn't affect that very basic truth. They may get housing benefit, but the adult would also get housing benefit. They get child benefit, which is about 55p, what is it called? Which is about £2 a day. But otherwise, the adults get all their needs of the sort that Baroness Hale has just been describing in the passage we're looking at. And not school trips, because I don't go on school trips, but shoes and other matters of that, and food, crucially. The children don't. They are left out of the assessment. And discounting a child from a benefit calculation is a fundamental create a fundamental problem with the human rights principles of equality and dignity, as we've tried to say in the printed case. There is the additional element which we deal with in paragraph 57 of the printed case, which is that in addition to them being the only class that are left out, the creation of a situation of worsened child poverty, which we say this policy does, creates a particular problem for children. You know, court can read for itself, paragraph 57. and in particular the quotation from the judgment of Lord Wilson in DA. We have children uniquely left out of the equation in years when there is likely to be an obvious and extremely detrimental effect on them. If the result isn't the necessary result, but if the result is a long period in poverty, then the results are those spelled out by Lord Wilson in DA in the citation from paragraph 34, which was in the DF 103. So those are my submissions on why there is discrimination against children as opposed to adults. We've hinted at some of the answers to the justification arguments produced by the Secretary of State, which aren't many on this part of the case, before the section of our printed case dealing more generally with justification, which I'll come to in the fullness of time, I suspect, relatively early tomorrow morning. Now, the next issue is our case that the two-child rule discriminates against members of households with 3 or more children. We deal with this in DF 103 through to 105. And obviously the first building block is the issue of whether or not the identification of a household of that type, household with 3 or more children, have a status which sounds under Article 14. And we say the Court of Appeal gave the correct answer to that question at paragraphs 74 to 77. Which the court will find EF, the passage as a whole starts at EF 220. I think paragraph 70 through to 73 discuss the approach of Mr. Justice Ouseley at first instance. But then Lord Justice Leggett himself picks up his own approach. He says, I agree with the judge that in identifying the relevant group for the purpose of the claimant's discrimination argument, the use of the term sibling is not strictly apt, as in the way the legislation operates. What matters is the number of children for whom the person or couple claiming child tax credit is responsible, and not the relationship of those children to each other. But a group which comprises 1 or more children living in the same household is either a single adult or a couple, who, even if they're not their natural parents, has responsibility for them, is a perfectly familiar social category, which reflects the way in which the care of children in our society is normally organised. Such a group can naturally be described as a household or family, or a family. Indeed, those were the terms used when the two-child limit was explained and debated during the passage of the bill through Parliament. Furthermore, the basic distinction which this measure draws, and is deliberately designed to draw, is a simple one, encapsulated by referring to it as the two-child limit, between a household which contains 2 or more children and a household which contains more than 2 children. Whether or not the difference in treatment is based on this distinction can be objectively justified. The claimant's argument that it's unfair is easy to understand. Nor is it diminished by the fact that, as is necessary in legislation of this kind, the classifications for which I'm using the terms child and household and or family for short are given more detailed and elaborate legislative definitions. The judge's reliance on the bootstraps argument preceded the decision of the Supreme Court in Stott, which, as I've indicated, makes it clear that while the allegedly discriminatory treatment cannot itself be a status, there is no requirement that the status must have social or legal significance outside the context of the legislation, and apart from the fact that it is the ground on which the allegedly discriminatory treatment is based. In this case, the claimants are not simply complaining about the fact that they're denied a benefit to which others are entitled. They are complaining about the ground on which this difference in treatment is based. Not an objection to their case that the relevant status is given precise definition of significance by the legislation which uses it as a ground for treating people differently. It seems to me that once it's accepted that a status need not be innate or an inherent aspect of an individual's personality, there may be a feature of a person's circumstances, a living situation on which their legal consequence depends, and being a member of a household of such being a member of such a household can without difficulty be regarded as other status for the purposes of Article 14. Such a status is not different in character from being homeless, or prisoner serving a sentence of a particular type, or being resident in the UK, or being an immigrant has been given to leave in particular conditions, subject to leave to remain on particular conditions. A.R. Serbia, where it's common ground and regarded obviously correct by the Supreme Court, as a family with a child claiming asylum in the UK who arrived in the UK without parents or not as a part of a family unit was a status. Another comparable case is DA, in which I consider in more detail later in the judgment, where being a lone parent of a child under two, or a child under two with a lone parent is held by the Court of Appeal to be a status. I conclude that being a member or a child member of a household which includes more than two children is a relevant status. Such a discrimination in the provision of a child tax credit on that ground is prohibited by Article 14. Having said that, it's not a classification of a sensitive or suspect kind which requires particularly convincing or weighty reasons to justify making it a ground for treating people differently. Nor is it a status such as being a child or even a member of a family may be regarded as an important aspect of an individual's personality in the sense of what makes someone the person he is. A number of other children living in the same household at a particular time is a relatively incidental feature of a person's situation, and considerably less significant than, for example, the fact that a person is homeless. Therefore, agree with the judge's alternative conclusion that in terms of Lord Walker's model of concentric circles, the status lies on the outer periphery. Now, we say that two unsurprising things from our perspective. First is that the reasoning on whether or not there is a status is correct, fits with the Supreme Court's approach in DA. It fits, and indeed is an easier analysis than the position in the earlier Supreme Court case of Matheson, where the child who was in hospital for more than 84 days had a status in comparison with other disabled children. This is a stronger case. So we say that the analysis I've just read to the court is plainly correct on whether or not there's a status. We don't accept that the status can be confined to the outer edges of sensitivity. We've given the reasons for that approach in our printed case. In our printed case, indeed, it's that paragraph 58 through to 61. Or the core of the argument being in paragraph 59 at EF 104. No doubt Lord Justice Leggett is right to say that position of a child in a large household may be relatively transient, and therefore less sensitive than, for example, being homeless. But in very large numbers of cases, that will not be the position. The discrimination that's inherent in this case in this rule, against the position of children in large households, we say is something that the children concerned can't affect, not even to the extent you could avoid being homeless, as in the RJM case. And we say it is a relatively sensitive ground. So that's the outline of our case on discrimination against households with 3 or more cases, 3 or more children, sorry. You'll have to deal with justification in the fullness of time. Court may have seen that Lord Justice Leggett, on this part of the case, dealt with justification in the judgment at paragraphs 155 through to 159. The core of the justification argument on this part of the case is in paragraph, sorry, I should have given you a Lord Court EF numbers, EF 244, 245. Core of the justification argument on this part of the case is in the second half of 156 through to 158, and I will deal with that when I deal more globally with justification, probably now tomorrow morning. Can I just flag up before we leave it for the purpose of the next case? Those paragraphs do include comments about the extent to which the executive or government did confront the best interest argument. That's the next section of my submission. The Lordship will see that in the about 5 or 6 lines into paragraph 155, Court refers to the extent to which the government considered best interest, saying, he's drawn attention to the fact that Parliament taken account of the human rights considerations in making its decision. We'll have to look at that tomorrow. As far as the government as opposed to Parliament is concerned, his view is the fact that government did not confront the detriment that would be caused to the interests of the children affected by the child limit and to its greater scrutiny than would otherwise be appropriate. It goes on to say, Obviously, sounds in this passage as a whole. The ground is not a sensitive characteristic or suspect ground of discrimination, which can only be justified by very weak reasons. So it is a peripheral kind. The report can properly be used as a basis for some differential treatment, provided there's some rationale that the distinction is not arbitrary. So it fails that test. For present purposes, there was the court proceeding on the basis that the executive had not engaged in consideration of the best interests of the children. Not didn't engage in detailed consideration, didn't engage in it. And your lordship will see the same observation, middle of paragraph 158, EF 245. In circumstances where the measure was scrutinised and debated by Parliament during the passage of the bill, where the interests of the children affected, although given scant consideration by the executive, were considered by the legislature as part of that process of scrutiny, and where at the end of the day of the process Parliament enacted the measure in primary legislation, the court should be very slow to disgrace the balance struck by Parliament on a contentious question of social and economic policy at this time. So he's proceeding, highly relevant to my next section, which is to deal with best interest. He's proceeding on the basis that the executive gave scant regard, scant consideration to the best interest issue, and that you could make good or should make good that lacuna by having regard to the fact that the issue was debated in Parliament. That does raise the issue of how this court should approach parliamentary debates where best interests are mentioned, but where there is no statement by the executive or anybody else of what the best interests are in clear terms and how they were outweighed by the countervailing considerations. I'll try to make good that approach by taking the course in due course to Lord Nichols in Wilson. The stepping stones on the way are what is the content of the best interest consideration and indeed the other obligations, in particular under Article 26 of the UNCRC. Some members of the court will be very, very familiar with the benefit cap legislation, which considered the best interest issues. I think it's possibly worth at least flagging up as an agenda. Lord Carnworth's approach in SG, Lord Wilson's approach in DA, and then moving on to Lord Nichols in Wilson. If we can ask the court to pick up Lord Carnworth in SG, the court will find that at the head note at least at 1373 of the electronic manual. Court will remember that Lord Carnworth held that there was a breach of the Article 3 obligation based on the United Kingdom, but that it didn't matter for the purposes of the case that was presented on the basis of discrimination against women in connection with their property rights under Article 1, Protocol 1. And the other members of the majority in SG Lord Reid and Lord Hughes are the same. So the footnote records, a head note records the position just above letter E in the middle of page 1373. It followed that even on an assumption by Lord Reid and Lord Hughes, or an acceptance by Lord Carnworth, the Secretary of State had failed to show how the housing benefit regulations 2006 were compatible with the Article 3.1 obligation to treat the best interests of children as a primary consideration. Such failure did not have any bearing on whether the legislation unjustifiably discriminated between men and women in relation to their enjoyment of their own P1 rights. It followed further would be inappropriate to substitute a test of non-compliance with Article 3.1 for the accepted test of manifestly without reasonable foundation. And accordingly, since on the latter test the schools affected the measure had been justified, there had been no violation of Article 14. So one goes next to Lord Carnworth, who held there was a breach, which ultimately didn't matter, at page 13, paragraphs 105 to 182, which the court would find at EF 1405. He sets out there what he describes just above letter D as the most authoritative guidance now available in respect of Article 3.1, General Comment 14, adopted by the United Nations Commission on the Rights of the Child, not available. So the decision on the challenge, understand it's intended as a restatement of established practice rather than new procedure. And then the guidance refers to the substantive right under A. That right is of the child to have his or her best interests assessed and taken as a primary consideration when different interests are being considered in order to reach a decision on the issue in state. And the guarantee that this right will be implemented whenever a decision is to be made concerning a child, group of identified or unidentified children, or children in general. And then C is this rule of procedure whenever a decision is to be made that will affect a specific child or identify a group of children or children in general. The decision-making process must include an evaluation of the possible impact, positive or negative, on the decision of the child or children concerned. Assessing and determining the best interests of the child require procedural guarantees. Furthermore, the justification of a decision must show that this right has been explicitly taken into account. In this regard, state parties shall explain how the right has been respected in the decision, what has been considered to be in the child's best interest, what criteria it's based on, and how the child's interests have been weighed against other considerations. Now, stopping there, we say, looking at the position of the executive, it's crystal clear and was found by the Court of Appeal that they did not evaluate the possible impact, positive or negative, decision on the child or children concerned. They did not show how the right has been explicitly taken into account, and they do not explain, the executive does not explain, how the right has been respected in the decision. That is what has been considered to be in the child's best interest, what criteria is based on, and how the child's best interests have been weighed against other considerations, be they broad issues of policy. The knock-on effect, the complication in this case, which I'll come back to, is that we are, of course, dealing with my claim for a declaration of incompatibility, that the primary legislation is incompatible with conventional rights, rather than a complaint about the specific action of the Secretary of State, who would be the target if we were dealing with the Section 55 duty of the Section 55 duties laid on the executive. Here, the obligation is laid on the United Kingdom, but the obligation must discharge the components, we say, that are contained in General Comment. General Comment 14, which are plainly finally endorsed by Lord Carneth himself and then subsequently in DA by Lord Wilson. The knock-on submission is that when one comes to reliance on parliamentary materials, it is no doubt possible to conceive of a case where Parliament passes a resolution to the effect that we consider this legislation is incompatible with the best interests of the children directly affected by the cap, but justified by the countervailing considerations. But that's not this case. What you have in this case is simply a reference to a whole series of points made in debate, some of which are alive, certainly, to the best interests of the children, but all of which fall to be considered in the light of Lord Nicholl's observations in Wilson about the dangers of imputing to individual members of Parliament, the other way around, imputing to the legislature or the executive as a whole points made in debate by individual members of Parliament just doesn't do the job. And accordingly, we say that can stop Lord Justice Legate's acceptance that the executive did not scrutinise the best interests of the children or identify the countervailing situations, and you roll that together with the correct and sensible approach to parliamentary debates, you get a situation where the United Kingdom cannot demonstrate that it has discharged the Article 3 law duty. Some of that I'll have to leave for tomorrow. Can I just finish?
But just before you do, Mr. Drabble, but when you come to deal with this more fully tomorrow, as well as Lord Nicholl's, you might want to look at what was said in the HS2 case.
I've been telling my junior to do that for days.
Well, you can buttress your admonition to your junior with the advice coming from the court also. But we would like to be referred to that.
I think that's why.
And it would also be useful for us to have perhaps a note. It strikes me, looking at the documents in the case, in the appendix, there was a colossal amount of material put before Parliament. It's not just debate. There are committee reports, there are lobbying organisations, special interest groups, representations. There's a huge quantity of material. And it would be useful for us at least to have a note of what material was before Parliament, I think.
Well, I'm sure that's been heard, and
right.
It may be an enormous task, but we.
Well, in a way, that's an interesting response.
I mean, obviously that cuts both ways. I mean, your lordship will have the taste of my answer. There's a very specific duty in Article 3 terms, not just to be confronted by a mass of material, but to analyse it and come to a view as where do the best interests of the children lie? Is this measure compatible with them? And in what way do if it's not, in what way do the countervailing considerations outweigh the best interests? You've got to come to that end point. It's no good just, my submission is, no good just saying there's a mass of material. So that your lordship is right. I mean, there is a mass of material. And we'll try to synthesise down that argument.
Thank you. Well, in that case, I think we can adjourn there for the day, and you would like us to resume, was it 10 o'clock tomorrow morning? I
think, I'm looking at Sir James, but I think, as I understand it, we're both agreed that if we start at 10 o'clock tomorrow morning, we can see where we've got to, and there's enough flexibility in to make decisions about whether more time is needed or whether we can finish on the timetable.
Yes, well, that's fine. And in that event, you can bear in mind that we would want to have a short adjournment about mid-morning. So say in that event about 11:30.
Right.
Very well. We'll adjourn for the day. Thank you all very much.